now open. Please be seated. Good morning.
Thank you. Good morning, everybody. Welcome to the Appeals Court. Today is February 4, 2026, believe it or not. And your panel today, I'm Justice Massing. To my right is Justice Neyman. That's Neyman with a Y. And to my left is Justice Smyth, also with a Y. And we have, we're hearing 6 cases today. We have read all your materials, so you can start right into it. Each side gets 15 minutes, no rebuttal in the Appeals Court, so you can just jump right into it. As I said, you have 15 minutes. You're free to use it all, and you're free to finish early. There's no penalty for finishing early. We have your materials on these handy tablets, so if we're looking at our tablets, it's because we're looking at case materials, not for any other reason. And with that, I will call the first case today, which is 25P502, Commonwealth versus Christian VERDE.
Yes.
Good morning. Is it Kahanowitz?
It is, Your Honor.
Got it right.
It is. Good morning to the panel. As Justice Massing just indicated, I am Attorney Ian Kahanowitz for the appellant Christian VERDE, and may it please the court. Your Honors, I bring 2 issues with me today regarding the trial case and the jury verdict. The first issue is we deal with the motion to suppress and whether the judge erred in denying the motion to suppress the evidence because the police did not have a warrant to search and seize the appellant's gun and ammunition and had proper consent to search the apartment because there was coercion. The issue 2 that I will present was the verdict of the unlawful possession of the firearm and ammunition in violation of General Laws 269, Section 10A, should be vacated because the non-resident firearm licensing scheme, in effect at the time of the defendant's arrest, which was back in 2021, was ruled to be unconstitutional in the Supreme Judicial Court case of Commonwealth versus Darnell. As it states in my brief, I'll begin with the apprehension of the appellant. Appellant came in, he was waving a gun in the officer's room. He was approached by the superintendent. He put the gun away after backing off, holding the gun to the superintendent, went back to his apartment. The office rightfully called the police. The police came. I believe Officer Grunwald, who was one of the officers there, said there might have been up to at least 10. Some had rifles. They all had ballistic shields. The dispatcher told the appellant, please leave the apartment, come up. He complied. He had his hands up. Officer Spellman decided to approach him with the ballistic shields. Again, everyone's guns were drawn. My client complied. There was yelling, screaming.
So okay, I was with you all to then. What's the evidence that there was yelling, screaming?
The Officer Spellman testified to that there was yelling and screaming.
Didn't he testify that by the time, actually, I don't know if he even testified there was yelling and screaming, and if you could give me a transcript site for that.
Absolutely. It'll be in transcript 1, page 288. And in there...
Is that at the trial?
That was the trial.
So we're talking about the evidence at the motion to suppress, aren't we?
Excuse me. That was the motion to suppress, I believe. Transcript 1, which was...
No, the motion to suppress looks to me like it's only about 77 pages.
Oh, okay. All right. That's my bad, Your Honor. But yes.
Okay, so there's no screaming and yelling, at least as the motion judge.
Okay.
And the officer testified that, in fact, that once he came out and things were calm when he asked him if he, where the gun is. In fact, they gave him his Miranda warnings first, right?
They gave him his Miranda rights, and not only that, they cuffed him and they asked for consent. Now, I would argue this. They did not give him the right not to consent. It was never mentioned to him, which is specifically in the statute and in the North Attleboro police procedures, you have to notify who you're apprehending a right to refuse.
I think the case law says it's certainly not dispositive. That's a factor
It is a
that
factor.
the judge has to consider.
But if you also look at the case that I cited, which is Harmon, even if you detain him, and even if that applies as well, is when that happens. So again, I will cite Commonwealth versus Harmon. The guns were drawn, police were going into a one-bedroom apartment. There was several uniformed officers. They gave him his Miranda rights, they cuffed him, and they said, hey, where's the gun? We're looking for a gun in plain view. And the Supreme Judicial Court said, even if you detain him, and even if he's apprehended, these rights apply. So when we come down to the situation, we're looking at a totality of the circumstances, Your Honors. The Commonwealth would have you believe, and I would say, well, look, it's in their brief. It was calm. The appellant was smart enough. He was able to answer the dispatcher at the time and say, yeah, all right, I'll come out. And then all the guns were pointed at him, and he got on his knees. He complied. But even in his testimony at trial, and again, we're on a motion to suppress, even at the motion to suppress, he said, look, I was afraid. They have rifles. I was overwhelmed by the amount of police that were there. There was guns drawn. There was...
Wait, he testified at the motion to suppress?
Was that?
Did he testify at the motion to suppress?
I think he did, yeah. If not at trial. My memory eclipses me right now, Your Honor. But...
the transcript has testimony of Arujo, Spellman, and Grunwald.
Yep, and those are the three officers.
So you just said that he testified that he was afraid?
Yeah.
That's at trial.
That's a trial, yes, excuse me, Your Honor. But still, the logic is...
So these are very factually specific inquiries. And you mentioned when he came out of the apartment, the defendant, he was on his knees and handcuffed. It was unclear to me from the transcript if he ever got off his knees. Was it clear to you if he...
It was not clear to me that he got off his knees, but...
But the entire time an officer was holding him...
Right.
Or not the entire time, until the detective came back out, the officer testified he was holding him, correct?
Correct, he was. And so, again, he was guarded, just like the facts in Harmon. He was guarded. The police officers went into the appellant's house. Again, they saw the gun, they came back out, and they even asked him further, where's the ammunition? Again, there was no consent. They just came out.
But you'd agree the defendant in Harmon had some different characteristics. For one, he was intoxicated, correct?
Correct.
And that may be a factor that influences whether a person gives voluntary consent?
It is, but also...
No intoxication issue in this case, correct?
No, there is a case of marijuana. They smelled marijuana originally. They sent the supervisor over, and he knocked on the door, and the appellant said, listen, you can't come in here. It says 24 hours. You got to give me a heads up before you come in. So there was no marijuana test or any drug test.
He testified he was on Zoloft, correct?
Right.
Was it?
It
And
is.
what do you make, counsel, of his interview later? I mean, obviously, what he characterizes as the nature of the consent doesn't have legal force, but he pretty much says it was consensual. He says he gave them permission.
He did give him permission, but that comes onto the whole thing of coercion. Even if you acquiescence to the police, there still is the factor that, again, as the North Attleboro Police Procedure says, there can't be any indicia of any coercion, intimidation, or threat. So officers must avoid even the appearance of intimidation or duress. Now, Your Honor, if I had guns pointed at me, someone coming after me with a ballistic shield, I wouldn't be calm. Not within 5 minutes, probably not within an hour. I'd probably still be having nightmares today from the kind of force.
Harmon is your best case?
Harmon is my best case.
In Harmon, didn't they tell the defendant, if he didn't give them permission to open the box, they were going to break it open?
They did.
But in here, essentially, he gave them the key, then he told them also how to open it. You have to
Yes.
do it a certain way.
Because
Would that be
they-
different than the circumstances in Harmon?
I would believe in Harmon, it would be more of a more vigilant stance by the police. But here, again, what we're talking about is the totality of the circumstances. I think the circumstances are the same. I think by giving Harmon's rationale, the damage was done already through coercion. Whether he said in Harmon, I'm going to break the box open, whether you give me the key or not, you can say here that, look, he gave the key by consent, but how was that consent? With rifles pointed at him, then pointed down, ballistic shields, and being held by the officer while they went to investigate into the house?
Well, isn't it fair to infer, and isn't in fact, I mean, doesn't the evidence even show that when he came out with his hands up after, which he had agreed to do with the dispatcher, that at that point the ballistic shields went down when he was, there were no guns pointing to him when he was asked for consent to.
Here's the thing. When he came out, his hands were up. When he went down on his knees and and the officer came over to arrest him, he still had his ballistic shield up. The police still had their rifles up. And when he put his hands behind and Officer Spellman arrested him, then everything went down. I think that is a mark in time, which is the difference between coercion and no coercion. That is all I have on that issue, Your Honors. If there's any more questions, I'll proceed to issue 2.
As to question 2, the Commonwealth argues that Donald applies only to non-residents, and your client was a resident. So why is the Commonwealth incorrect?
The Commonwealth, and I went over that a few times. Now, here is the history of the appellant. The appellant lived in Florida. Again, he was in Massachusetts for at least, I believe, 6 months. And again, jurisdiction here, I think they have.
I thought it was 18 months.
Was it 18 months? Okay.
so.
All right, so we say he was a resident. Here's the finely tuned issue for this court. Donald also was not a resident here, and he did not apply for a license.
No, not also. Your client is a resident.
So if we say, if we say by the circumstances that he has a job here, that he has an apartment here, even if he was a resident, the other statute would apply as well. We're talking about Second Amendment rights here. He had a license for his gun and ammunition produced in Florida. I'm not sure if this has ever come up.
So I still want to go back to my
Ed.
original question, which is, do you agree that Donald applies only to non-residents?
I do. I will agree to that. I will agree to that, but what I also will let you know is, again, this is 2021. He was charged under Section 269-10A. Again, we know through Donald they used the Braun case from the Supreme Court. We know that when you look at the statute, the distinction between the Second Amendment rested on may rather than shall. And so the scheme itself, the licensing scheme, even if he applied for it to say, it would have been unconstitutional because, again, it was so intertwined you couldn't separate it, which is a violation that the Supreme Judicial Court found here and threw it out, and it was amended. And now it says it shall. But I think when we
Now,
deal...
so you're familiar, I think it was September, the Commonwealth v. Rodriguez.
Yes, and that...
Did that abrogate Donald?
No, because there in Rodriguez, you have someone applying who was convicted of a violent crime. And my client did not have a violent crime prior to this this incident. So again, it would not
Are
apply.
you arguing a facial challenge or an as-applied challenge?
Excuse me, repeat that again, Your Honor?
Are you arguing a facial challenge to the statute or as-applied to your client?
As applied to my client, the facial challenge was already done in Donald. He couldn't, he didn't have standing to do this. My client has standing. He was secure in his home. Granted, he came out, he said, look, I never brought this out. I had possession, it's in my house, I had a license, it wasn't Massachusetts license. I think that's the narrow issue that this panel has to do here. We have a Floridian license. My client didn't realize the whole parameters of what happens up here, how to get a license. And even with the license, to purchase, to carry, and to sell are the three things that the licensure officer testified at trial. He didn't do any of those. All he did was have possessions. It brings in Second Amendment rights as well, Your Honor. If there's no other questions by the panel, my dissertation is done.
Okay, thank you.
Thank you.
We'll hear
Thank
from
you.
the Commonwealth.
Yes, good morning, Your Honors. Excuse me. My name's Rob Kidd. I represent the Commonwealth of Bristol County, Massachusetts. Turning to the Donald decision on the second issue first, I would point out that the Rodriguez case and Donald and a number of cases consistently point out that in order for the defendant to make an as-applied challenge to a statute, to the gun licensing scheme, he must first show that he applied for and was denied a license under the Massachusetts statutes, and that is not the case here. So I'd suggest that those cases are inapposite, and the defendant loses on that basis. Going back to the voluntariness issue, I would just let the court know that you have a situation here where this defendant, as I point out in my brief, there's no evidence that he was upset or angry or was afraid. The evidence is what it is. He was described as being calm. He was described as being cooperative in the hearing. He had the presence of mind to, after being read his Miranda rights, which is a factor that this court needs to consider, he had the presence of mind to give his key to the officer, to instruct the officer how to use the key, and the officer successfully entered the apartment. He was able to direct the officer to where the ammunition was, where the gun was. I suggest to you these are not the acts or the actions of a person who was overly frightened or panicked or emotional. I also would point out to you that there's no evidence that I find in the transcript to support an inference that the officers were pointing their weapons at the defendant when he gave consent. The evidence was that they immediately handcuffed the defendant after he kneeled, and as soon as they handcuffed him and he was secured, all the officers put down their weapons, or yes, holstered their weapons. And I have that cite in my brief. I don't.
So when the judge didn't make specific findings about that or as to credibility, we rely on the record?
Yes, yes. The judge, the findings were pretty brief, and he just simply found that there was consent. I think in the scheme of the way the hearing proceeded, I think we can infer that the judge was trying to say that the consent was valid, because during the hearing it was argued that there was no valid consent because of coercion. So, yes. I would also point out, Your Honors, that this is a 27-year-old male who testified, told the police, I should say, after this incident. He told the police that he was a professional who was employed in some sort of tech job, so he was an educated individual. He appears on that videotape that the motion judge saw speaking to the police. You can see that motion tape. You can see his actions. Inferably, that interview occurred shortly after the incident. He is calm, and he is able to communicate with police. There's no indication that he was under the influence of drugs or alcohol. I know that marijuana was said to be involved, but he certainly is articulate and clear-headed when he speaks to the police. During his 911 call, he is, you can hear his voice. He tells the 911 operator, dispatcher, yes, I do have a weapon, and the dispatcher says, under no circumstances do you bring that weapon outside. And he calmly says, oh, that's okay. He says it was self-defense. I'm going to put it down. Also, importantly, I would note that the evidence at the hearing showed that when the maintenance fellow went over to the defendant's apartment and he tried to go into the defendant's apartment, he bluntly refused entry, and I believe he yelled at the maintenance person. There were words exchanged. I would respectfully suggest that this shows that the defendant was aware of his rights, aware of his rights not to allow people into his apartment, and it shows a person who is not, if you will, a wilting flower against authority. So I think that the court should also consider that. I would also like to make a broader case about a broader point about the case of Commonwealth versus Harmon, and that point is, Your Honors, that Harmon involved an interlocutory appeal of a motion to suppress that a judge allowed below, and the court in Harmon couched that in terms of giving deference to the motion judge, and they even said in Harmon, the court even said that, you know, this could have gone either way, but the judge has found there was evidence to support the judge's decision. And that evidence, as Your Honors pointed out, was this defendant was of below average intelligence. This defendant had been drinking, and there were some other factors as well. So the law says that, the law talks about that there must be a finding that the judge was clearly erroneous when he makes a finding of voluntariness. So the court in Harmon said, we are not prepared to say that the judge was clearly erroneous in this particular case.
So unlike other Fourth Amendment issues, on the issue of consent is purely a factual issue, so we're reviewing for clear error as opposed to doing an independent assessment of the facts to the law?
That's what the body of case law that says that, and I think there's some case law that pushes back at that. So I'm a little unclear on that myself, I'm going to be honest, because there are other cases that say, what does that exactly mean? Does that mean we get to, we have to give the judge deference if he says that this is a voluntary act, if there's consent? That seems to be maybe a legal issue, but that's what Harmon says. I think that's a bad answer, but that's all I can let the court know. So, yes, I don't, as far as that is concerned, as far as the consent is concerned, those are the major factors. Your Honors can look at the transcripts, obviously, look at the briefs. I would suggest to you there was certainly enough evidence for this judge to make the finding that there was voluntariness with respect to consent. As to the other issue, I was going to point out the Rodriguez case. The court is aware of it, counsel is aware of it, so I would ask the court to consider that. I don't see a need to address the second issue unless the court has any questions about either issue.
I have one question about, was there evidence that he had a license in Florida, or was there evidence that you didn't need a license in Florida?
I think it was the latter. He produced, at trial, he produced a receipt for the weapon that he purchased over the counter in Florida. That was the evidence. So he didn't have a license, any license anywhere, and apparently he was able to do that in the great state of Florida.
Okay, well, we don't have any more questions, so if
Thank
you don't
you.
have anything else to say. Thank you. Thank you both.
Thank you.
Case is submitted. Okay. Me too. So the next case we have up is 25P510 Commonwealth versus Durand. Attorney Dolberg, good morning.
Good morning, Your Honor, and may it please the Court. And indulge me for a moment, this is my last oral argument before I retire this spring. I just want to say it's really been a pleasure to appear before the Appeals Court, and I'm feeling very bittersweet about it, so, but
I'm sorry to hear that.
that's not why we're here today.
You will be
I'm here-
missed. Thank you.
Thank you. I'm here on behalf of Mr. Durand, and I'm asking that the Court vacate the conviction and enter a finding of not guilty by reason of lack of criminal responsibility by reason of mental illness. There was insufficient evidence to find Mr. Durand criminally responsible for his conduct on July 31st, 2021. It was the Commonwealth's burden to prove criminal responsibility beyond a reasonable doubt, something it did not attempt to do at trial. because after careful consideration, the prosecutor agreed with the defense that the defendant was not criminally responsible. The Commonwealth's attempt to abandon that position now on appeal and cherry-pick words from the Lowell General Hospital records cannot really be countenanced. Here it would mean that Mr. Durand had no opportunity to provide clinically based response. And it also would mean that any defendant in this position would be loath to enter into any stipulation as to the evidence or to...
Well, actually, though, if there had been a stipulation, wouldn't that be helpful to you at this point?
Well, this was an evidence-stipulated trial, and I think in this case, it wouldn't have been entered into if the Commonwealth can simply change its position on appeal, which I would ask the court not to consider these arguments because I would say they were waived after Vameng Zhou. The Commonwealth...
But I read that carefully, and I mean, don't they also have an obligation, though, to argue, to now that the judge has ruled, to sort of defend the judge?
No, I would disagree because, first of all, the Commonwealth didn't present a case. In its brief, it outlines the Commonwealth's case. It wasn't a Commonwealth's case. This assistant district attorney was very, very clear. He explicitly said he did not challenge the doctor's conclusion that Mr. Durand was not criminally responsible, that in fact he'd been suffering from schizophrenia that made it impossible for him to appreciate the wrongfulness of his conduct or to conform his behavior to the laws. He conceded that he thought the court was compelled to find him not criminally responsible and that the evidence supported that verdict. And now the Commonwealth is coming forward with some words from hospital records that don't undercut the expert's opinion, which the judge did not discredit, by the way, and the judge offered no rationale for his conclusion.
Also, a general question. Did you find any cases in which the Commonwealth conceded they hadn't met their burden and a judge or a jury came back guilty?
There are no cases where the parties have agreed. I could not find any cases where the parties had agreed and the judge discarded that. The closest case I have is Garcia, where that was a Section 16 case, as I talk about. And in that case, the judge, as here, indicated that he was going to deprive that defendant of liberty based on his concern about the defendant's failure to take medication. That's very similar to this case because the judge here is very clear in denying his motion, the defendant's motion to stay, that he wanted to keep him on probationary terms so that we know that he continues on the path that he's directed towards now. That's very similar to Garcia. And if Mr. Garcia was kept for 40 days and that was impermissible, then imposing a criminal sanction as here would certainly be impermissible.
The judge stated that after the verdict, correct?
Yes, he stated that after the verdict, but he provided,
It seems to me that that would be a problem if the judge stated that before the verdict or as part of the verdict, but stating it during sentencing, it's subject to different interpretations.
Well, it may be, Your Honor, but he provided no rationale for his decision. He actually, on another...
No rationale for which decision?
For his decision to find Mr. Durand guilty.
Okay, but we were talking just now about his decision to put him on terms of probation, supervised probation. To me, that's a different ball of wax. So let's get back to the issue at hand, which is whether or not the evidence, and I understand your arguments that you're making about the Commonwealth changing its mind after the verdict or changing its approach. But the question before us is whether the evidence viewed in the light most favorable to the Commonwealth is sufficient to support the verdict. You say the answer is no.
Right.
The Commonwealth points to the medical records and the evidence at trial, including things like the defendant asserting his right to counsel before answering questions, including the defendant saying to people before he struck the nurse with the fire extinguisher, which we have on video and have watched, hey, watch this, and other statements he made, which they say tends to show that he could conform his conduct, number one, and number two, that he was aware of what he was doing, for lack of I'm paraphrasing the standard. Tell me why the Commonwealth is incorrect.
Well, actually, the Commonwealth doesn't mention the watch this, but that is in the record. Its reliance on language such as alert, oriented, and cooperative does not undercut a finding of criminal responsibility. And I will point out that while the Commonwealth notes the word oriented on July 27th, it fails to include the psychiatric assessment of flat affect, cooperative, delusional, and other symptoms: agitated, unkempt, anger, hostility, delusional, doesn't trust government institutions, police, insurance companies. And that goes on. So
For Lattimore and Lawson, don't we disregard that?
not as to those words, Your Honor. Those words.
That's negative information. I mean, we don't have to consider that even, do we, under, again, Lattimore and Lawson, light most favorable?
No, I would disagree, because I think these are entries that are of a piece. And Dr. Chenell described the symptoms of schizophrenia that caused him to offer the conclusion and the Commonwealth to agree. The Bridgewater records themselves, that someone is alert, oriented, or cooperative does not mean they're criminally responsible. It doesn't mean that they understand the wrongfulness of their conduct and can conform to the laws.
But how about in connection with the other evidence, including asserting the right to a lawyer, including and not willing to speak until he has a lawyer, accusing the patient of trying to set him up, and all of the other things the Commonwealth points to that are within the medical records?
Part of he had multiple persecutory delusions, including that people were trying to set him up. That was what occurred on July 25th, and in general, and throughout the records, throughout the Bridgewater, Tewksbury, and throughout the Lowell General records as well. So that's of a piece with his mental illness. The asking for a lawyer would also be very consistent with these persecutory complexes that he had, which included the district attorney, by the way, and unions. And when one reviews the records that Dr. Chenell reviewed, it's clear that he felt that everyone was against him.
I think that's a very persuasive interpretation, but another interpretation is I'm calling on a lawyer because I know what I did was wrong and I'm going to assert my rights.
Well, I think in the context of these records and the testimony of even of the police witnesses, that he was suffering from a mental illness, that he was paranoid, and that this continued. You know, he was found incompetent right after these incidents, was sent to Bridgewater for 2.5 years, and then Tewksbury for 10 months, and then to a group home, a DMH group home. So to cherry pick these words, that's part of the problem with the Commonwealth's position. If this had been brought up at trial, Dr. Chenell could have responded to these and said, those don't change my opinion because. And the judge was very clear what he was asking about. He was asking, was he medicated at the time? He asked Dr. Chenell that during the trial, and then he looked at the Lowell General records for a brief time and said they provided a great insight for him. The only insight they possibly could have provided is that Mr. Durand did not take medication. He refused it at Lowell General. So that's what is very consistent with his statement about being on probationary terms.
Can I ask what the relief you seek is for us to order the entry of a not guilty because of criminal responsibility? What's the sentencing or commitment ramifications of that type of a?
I'm sorry, could you repeat that?
Yeah, what was if it was a not guilty because of lack of criminal responsibility? What is the commitment, or what is the going to happen to the defendant?
So there could be a Section 16 hearing after that, and the Commonwealth asked Dr. Chenell to provide a risk assessment to see whether Mr. Durand would present such a risk that he should be sent for observation for 40 days. That's what happened in Garcia. And there's a report in the record, and Dr. Chenell testified, and the Commonwealth conceded that he presented a low risk. You know, as I said, he'd been at Bridgewater for 2.5 years. 10 months at Tewksbury and quite some time at his community residence, and presented no risk of violence, or a low risk of violence. And Dr. Chenell testified about that, so it wasn't an option at that time. That's what would ordinarily happen after that. If there are no more questions, I would simply ask.
Just,
that-
again,
Oh,
on a
yes,
more
of
general
course.
point, taking mental
Yeah.
health out of it. So in most closing arguments, you'll hear the Commonwealth argue the defendant's guilty. And the judge, of course, doesn't have to accept that. But here we have, you can interpret reasonably the Commonwealth's argument that we haven't met our burden. He's not guilty, Judge. So is there any burden on the judge at that point? With a moving party, the party with the burden of proof says that they haven't made it? Or is that just similar to he's guilty, Judge, because it's an opinion of the Commonwealth? What weight does that have, that statement?
Well, I think it has great weight. If the judge did disagree, I think it would be incumbent on him to explicitly, as the court said in Garcia, to discredit the expert's opinion and to explain why. Because here, the clear inference is he was trying to do as the judge did in Garcia and say that I'm concerned about this person in the community. I want to make sure he takes his medication, so I want to make sure the probation department monitors him. In that case, I think that would be required. The Commonwealth, it's very clear from this record that this prosecutor was very, very careful and analytical in his questioning of Dr. Chenell and his decision to support the conclusion of Dr. Chenell. You know, his cross-examination was very, very thorough and careful and established that Dr. Chenell had reviewed all the records, had
Right,
talked
counsel,
to...
but the case law just really doesn't have your back on that as much. The Commonwealth doesn't need to present an expert, and again, light most
Yes.
favorable, the language is pretty clear from Lawson and other cases that you don't have to we don't have to consider evidence that would be adverse to the defendant, or to the Commonwealth, excuse me. It's really light most favorable.
Yes, but in this...
We've argued that, but I
Right,
don't
okay.
think you're, well,
Yes, no, I think in this situation, as in Garcia, it would be incumbent upon the judge to explain why, and not to rely on an impermissible basis, which it appears he did here.
and have you seen any other bench trials or verdicts rendered by judges where there's an explanation required?
I think Garcia is the closest, and I think this doesn't come up because it's unusual, because for the Commonwealth to have so carefully thought about this and reach this conclusion, a judge would ordinarily agree with it unless they had a reason to not to, and then they would explain.
You're right that the Commonwealth chose its words very carefully at trial. The Commonwealth did not say we can't sustain our burden, or we have not sustained our burden, or judge, you need to allow a required finding of not guilty. The judge asked, did I hear you say the Commonwealth acknowledges he was suffering from a mental illness, he did not appreciate the wrongfulness of his actions at the time? The Commonwealth chose its words carefully. It said, yes, I agree, the evidence supports that.
Well,
The Commonwealth is saying that that is a conclusion that you can draw. But
No,
it strikes me that it did not concede that that is something that the court must draw.
well, I disagree with you there, Your Honor. He conceded that the court was compelled, quote, unquote, to find Mr. Durand not guilty by reason of mental illness on all counts. He said he was compelled. That was his opinion. So I think actually he did, I disagree
So
with you
what did he
respectfully.
mean when he said, yes, I agree, the evidence supports
Well,
that?
the judge specifically said, I want to clarify that you're saying the evidence, based on this evidence, he should be found not guilty by reason of criminal responsibility. But he was very clear, he used the word compelled. So I think that's absolutely where he was coming from.
Got one more parting shot for your last argument?
I think I'm good. Thank you very much.
Thank you.
Good morning. May it please the Court. Hallie White Spate, Assistant District Attorney for Middlesex on behalf of the Commonwealth. To anticipate
Can you pick up where we left off? So we have one statement by the prosecutor, which is that the evidence, I agree, the evidence supports the defendant's mental state as argued by the defense, and that's at transcript page 93. But then at page 90, the Commonwealth in closing states, that mental disease affected his ability to substantially appreciate the wrongfulness of his conduct, as well as his ability to conform his behavior, and as a result, I think that the court has then compelled, it's a little awkwardly phrased, but as a result, I think that the court has then compelled to find the defendant not guilty by reason of mental illness.
That was actually where I was going to start. I have never seen this before in a criminal trial, but there are some very basic principles that still apply. And the first one is what we say, what a judge says in every criminal trial, which is closing arguments are not evidence. This is not evidence. There was not a stipulation to lack of criminal responsibility. There was not a null pros in this case.
Was there a motion for required finding of not guilty?
At the close of the Commonwealth's case, defense counsel quite properly said, I understand since this is criminal responsibility, it's not really appropriate to move for required finding at this time. Defense presented its case. Things went on for a while. There does not appear to have been a second motion at the close of all the evidence, but I direct the court to Commonwealth v. Grandison. It's 433 Mass 135, which simply says we don't really require a motion because a verdict based on insufficient evidence is
insufficient.
Ipso facto a miscarriage of justice. And I don't know what was going through the prosecutor's head at this point. He is no longer with our office. I did not have an opportunity to talk to him about it. Whether there was some just feeling, I can't in good conscience stand up here and say he's criminally responsible because I don't think he is, but that's not the question. It wasn't the question for the finder of fact. It isn't the question for this court. It isn't what would I find, what would you find. It's what does the record support. And so the only question for this panel is there sufficient evidence in the record? And the defense had these records, the defense expert had these records. They were free to ask whatever questions they wanted of their expert. And I do want to point out, there is no allegation here that the Commonwealth somehow duped the defendant into presenting a less than complete case for the purpose of getting the conviction. That would be unacceptable.
I don't think the argument is that dupe, but I think it's more of an estoppel argument. I mean, should you be stopped from conceding one thing at trial and then making a different argument on appeal?
No, absolutely not. Nor is waiver applicable here. This is not a case where the Commonwealth argued some legal theory in support of some motion or some opposition to the defendant's motion and then tried to change its theory on appeal. We don't let defendants do that. We don't let the Commonwealth do that. This is a pure question of sufficiency. And sufficiency is entirely in the hands of the finder of fact. And so unless we null pros the case or stipulated to a lack of criminal responsibility, the judge was entirely free to go back, go through these records, and say, I am finding enough here to support a decision that the defendant understood that you shouldn't hit somebody in the head with a fire extinguisher, and that I could not do this if I chose not to. That's all this court finds. And this court does not ask, would I have agreed with this verdict? It asks, could a rational person have found this? And I think if you go through the records, and you can call it cherry picking, but you can also call it viewing the evidence in the light most favorable to the Commonwealth, which is what we do on every single sufficiency claim. I do want to briefly touch on the issue that seems to keep coming up, that the judge was somehow obligated to give the basis for his verdict. I know of nothing in the case law that requires that. And in fact, we wouldn't inquire of a jury what the basis for its verdict is. That's intruding on the province of the finder of fact. I don't think it's appropriate to ask the judge unless there's some very clear indication that the basis for the verdict was something impermissible, and the judge here simply announced his verdict. The only time when he talked about keeping the defendant under supervision to make sure that he complied with his medication regime was in declining to stay the sentence pending appeal. And the idea that the only thing he could possibly have learned from these medical records somehow was that the defendant was refusing medication, he certainly could learn that, and that could raise concerns for him. But the other thing he can learn from it is that the defendant was alert, oriented, cooperative at times, knew that he might be in some legal trouble for having smashed up his landlord's car, came up behind the nurse rather than attacking her head on, that he knew.
So I mean, you at one point you characterize it as creeping up. So, you know, we've all seen the video, and it's rather, I mean, it's not, he kind of nonchalantly walks to the, you know, to the desk, picks up the fire extinguisher and starts hitting the nurse on the head with it. What is that, what is the evidence that he appreciated the wrongfulness of that, or couldn't, or that it was able to comport himself to the law?
He came up on her from behind. And you can take issue with creep. Maybe it doesn't look like creeping to you. It did to me. But he's not rushing at her head on. He's coming up behind, so she won't see him. Now, is this as strong as the evidence in some of the other cases of, you know, concealment, trying to keep people from finding out? No, it doesn't have to be. But in conjunction with all the other indicia of criminal responsibility, of sanity, if you want to use that word, it's another piece of the puzzle.
What's your best case? Understanding these are all fact-specific, but what's your best case by analogy?
I think, I mean, they are all different. And is this the strongest case? Is this a slam dunk? No. But I think Lundy and Griffin are both, you know, at least in terms of the factors to be
Could you say that again?
considered.
The door was open. I couldn't hear. Say that.
I'm sorry, Lundy and Griffin. They're both cited in the Commonwealth's brief, like roundabout page 12 or 13. And all the records, the cites to the medical records supporting an inference of criminal responsibility are on, that's all on pages 13 and 14 of my brief. I won't go through them again.
And in Griffin, he hid the gun, right? The defendant, nothing similar to that, correct?
Could the judge have found he wasn't criminally responsible? Sure. Was he required to? I don't think so. I mean, yes, the cases, I could not find a case with quite these facts, but it's also very clear from the cases that evidence of mental illness by itself is not sufficient. Even evidence of highly delusional mental illness, as appears to have been present here, that by itself is not sufficient. That does not meet the legal definition of lack of criminal responsibility. And there was enough in these records that the judge could have found him criminally responsible, and this court does not disturb that finding.
You know, I have to say the elephant in the room, to me, there's a reasonable inference that there's a transference of obligation here. That the Commonwealth says, we don't have a case we can win, but there's real exposure. If we as a Commonwealth say, move for null pros, and 2 weeks later, this defendant takes a baseball bat or takes a fire extinguisher, that could be exposure to the Commonwealth. Why did they find that? You know, why did the Commonwealth make that decision? So it seems here the prosecutor went into this trial and concluded he didn't have a case. The Commonwealth did not have a case. But let's put it on the judge to make that finding. Let's put the burden on the judge to do what we should have done before the trial started.
I'm not sure I sort of understand the question. I think it is always up to the finder of fact to decide whether the Commonwealth has met its burden.
But doesn't the Commonwealth have an obligation to not bring a case forward if they don't think they can prove it, if they don't think they can meet their burden? They don't just say, Judge, we don't really have a case here, we're just going to let you decide, do they?
I admit it's irregular, and I don't like the way this happened. And were I advising this ADA, I would say, decline to make a closing and say, Your Honor has the evidence, you're the finder of fact, you know what the standard is, you can decide. And generally, I will say, as a matter of policy in our office, we don't bring cases that we don't think we can prove beyond a reasonable doubt. And that is, just for the record, somewhat beyond what the rules of professional conduct require. But don't think I don't think there's any evidence that there's anything improper here. You know, there is evidence. Whether this court thinks it's sufficient is, again, a matter for this panel. It certainly was up to the judge to decide that. I wish that had been made a little more explicit in the Commonwealth's closing, but I don't think that necessitates that this court reverse the conviction. If there are no further questions, I'll rely on my brief and ask this court to affirm. Thank you.
Thank you both. Really interesting case. You're giving us the responsibility of figuring it out, so thank you. The case is submitted. All right. Third case for this morning is 24P328, Commonwealth versus Anthony Roy. Just before you get started, so we have a brief from the defendant, but no brief from the Commonwealth. So you're permitted to sit at table to answer our questions. You're not entitled to argue on the brief, but we might have some questions.
Okay. I guess on that point, I would actually request orally here that I'd be allowed to file a Rule 22 memo in response to, you know, I'm not quite sure what the Commonwealth's position is here yet, so I haven't had a chance to respond to anything. Yeah, just to respond to whatever might come up. But on my argument, Ms. McFall merely acquiesced to the police's apparent authority and did not voluntarily consent to their entry into the home. And multiple factors show that this was just mere acquiescence. This is especially where the Commonwealth has to show more than simple resignation to the perceived power of the police. I think the biggest thing is that Officer Horvath made no attempt to ask Ms. McFall any questions. There was no phrasing of any sort of question whatsoever. It was simply a statement, I'm going with you.
So Ms. McFall's not a party to this case, correct?
No.
Is there any sort of standing issue?
I don't believe so, because it was in the room that they shared. I don't think there's a standing issue.
But you don't dispute that she did have authority to consent. Your argument is simply that she did not consent here under the totality of circumstances.
Yeah, I think any of those individuals outside had the apparent authority to consent to the police entry. I think they were all residents, so yeah. I think we can look at Officer Horvath's testimony where he says that he told her that he was going to go with her and that she complied with this request. And I think that language is important here, that one doesn't necessarily comply with a request, a voluntary request for a voluntary act. I don't think there's any other reasonable justification here. The officer doesn't, he kind of very cursorily says that there's a safety concern, but there's really no other indication that there's any kind of safety concern happening. Both officers that responded are rather nonchalant, kind of in their testimony, that people are bickering and arguing about stolen property, stealing each other's property and whatnot. There's no indication that that officer knew what property was even being stolen. That was another one of his justifications to enter the house, was to protect property, but I don't think he knew what property was being stolen. He didn't, on the record, he didn't even know which room was Miss McFall's. Miss McFall had to tell him, this is my room. He just followed her in.
But this is, this is a kind of unusual set of circumstances, right? The officer comes, there's all these people are outside, and she sort of asks permission if she can go inside, right? I mean, is she sort of asking his consent that she go in, that she be permitted to go inside?
Yeah, I think that's how it started. Can I go get my phone to call my mom? And so I think, yeah, that's already sort of deferring to his apparent authority, and then for him to step on that by saying, well, I'm going with you, without...
So he should say, well, wait, actually, no, it's your place. I've got to ask you, can I come in with you?
That would be good. I think something maybe... I think, perhaps if they had said something like, well, okay, if you want to do that, I'm going to go with you, or I got to go with you. Some sort of indication that she has some power here to say no. I'm not sure that if would be, I would probably still make that argument that it wasn't voluntary, but I think that would be better as well if there was some level of, okay, well, I got to go with you if you're going to do that. That way, she would know in that circumstance that she had some influence over what's going to happen versus, this voluntary request that she complies with. I think I can briefly turn to my second argument if there's no further questions on the voluntary consent issue.
Just even on that point, even if the officer, from your perspective, had said, may I go with you, as opposed to I'm going with you, that would have been more towards consensual?
I think so, yeah. May I go? I think that would be close to a question, if not a question, letting her know that she has this ability to say yes or no. Where I'm going to go with you is kind of forecloses her ability to influence that situation and sort of puts it on her to then tell the cop no when he says he's going to do something. And so I don't think that's a proper way to seek any kind of consent. On my second issue, just that essentially Officer Horvath doesn't actually adopt any recollection of where the drugs were in plain view. He testifies at the motion hearing that they were on the bed in a clear container. Then he recalls he's impeached with his police report that they were on the floor. Then he says, "You got me," and he doesn't really give any further testimony. So I think
He does testify, he's asked, did you have to move anything in order to find these items? And he said no.
right.
So I guess that begs this question. Let's assume the officer just testified, I saw them in plain view, which I think is, in essence, what he testified here to. And then he's asked, well, where? And he says, it was either on the bed or on the floor. I can't recall which, but I didn't have to move anything and I saw it in plain view. Are you saying as a matter of law that's insufficient?
I would say that that would be insufficient, that they were in plain view.
What authority do you have? What case for that proposition?
Let me pull up my brief. I think it's the Commonwealth versus King case with the leafy vegetable matter.
But it seems to me that the gravamen of King is that the evidence was insufficient to find that the items were seized in plain view. In other words, there was no statement by the officer that I saw them there, I didn't have to move anything.
Right.
Doesn't that distinguish King from our case where the officer said, I saw them on the bed, well, your police report says on the floor. Oh, well, I guess that's what I wrote, but I didn't have to move anything.
Right.
So, I don't know that King is directly on point.
Yeah, I mean, I would just argue that essentially that it can't be plain view if they have no recollection other than a vague recollection of not having to move anything, that we don't really know where it was if he doesn't testify to it, and so we can't say they're in plain view, that it's just sort of getting, he's
So your
testifying around the
argument
issue.
is if the officer cannot recall with particularity as to precisely where he saw an item in plain view, even if he says it was in plain view, that testimony is, as a matter of law, insufficient.
Yeah, or essentially that he's testifying to the conclusion that it was in plain view without, telling us where it was. So that is essentially a conclusory testimony.
Okay.
But if there are no further questions, I'm happy to rest on my brief.
Seeing none,
Thank you.
thank you.
May I
So,
please? Yes.
go ahead. You can say me. You can say hello.
Carolyn Burbine for the Commonwealth, Your Honor, and I apologize for the fact that we didn't file a brief. That was on me. We've had a severe staffing shortage. I'm the head of the unit. We have 3 appellate attorneys, and we should have 6, and we just couldn't keep up, and I lost track of this brief, and I apologize to the court and the defense counsel. That was on me.
So we shouldn't take your failure to file a brief as a concession of error?
No, Your Honor, it's not. We're not conceding that there was error by the motion judge in this case. We would disagree on both counts, both of the defendant's claims. It's our position that it was a voluntary, she said, yes, okay, that's exactly what she said. She asked to go in.
I think you're going to have to stop
I'm
there
sorry.
unless there's a question before you. Sorry, but
I
those are the rules.
apologize. Did the court have questions?
No, I think that's it. Okay.
All right, thank you,
Thank you
Your
for
Honor.
coming.
No, thank you.
Thank you both. The case is submitted. I think another one? We usually take a break after 3, but we're proceeding pretty quickly today. So we'll hear the 4th case, which is 25P465, Department of Children and Families versus Father. We don't have the counsel, we don't have? Okay, let's take the next case then. Sorry about that, thank you. So we're going to skip to the 5th case, which is John Doe number 190-908 versus Sex Offender Registry Board.
Impounded as well.
Yes. So I'll remind you that it's an impounded case, so we don't use names, we just use numbers.
Absolutely, Your Honor. All right, may it please the court, my name is Rebecca Rose and I represent the appellant, Mr. Doe. Your Honors, before I start my argument, I would like to take a moment on the record to remember Attorney Shania, Dave Shania, who wrote the red brief in this case, and he's argued many cases in this court, and I just wanted to offer my condolences to his colleagues and his family.
No, Attorney Rose, really appreciate that. I mean, we've all, saw Mr. Shania timeless numbers of times, and he was always, just a fantastic and very fair advocate, and we miss him too.
We lost a good attorney and a good man, and we lost another person in the CPCS office who also helped us all get here in these SORB cases, and we lost Rob Plosky as well. I'd like to just put that on the record. So, thank you. And in this case, in Mr. Doe's case today, the issue in this case is the substantiality of the hearsay evidence. The evidence of the uncharged crime that comes in the police report and the DCF records was too attenuated to be substantial evidence in this case, to be reliable. We're not arguing that it's not admissible. With the DCF records, the police records, it's admissible. The issue, though, is reliability. And in this case—
Actually, isn't the 4th issue in the brief that the DCF records shouldn't have been admitted?
That is one of the arguments that they shouldn't have been admitted. I think that was my argument today. Of course, I did not write the brief, but the argument is not that they aren't admissible, but that they are not reliable.
I think you're right. I think that the reliability is the question both for the DCF reports and for the other.
Correct, and especially as to the uncharged, the charged, but the crime that hadn't been yet taken to trial, the allegations. So, the first issue is that there is no direct transcript of what the boy said, and there's no transcript of what the grandmother said. So we have so many layers of hearsay here. We have what the boy reported to the grandmother, and she reported to one treatment person who talked to DCF, and then the boy was interviewed, but the police reports only have a summary of what the boy said. She didn't quite corroborate what the grandmother said. Then it was all the interpretations by the observers were written on the paper, and then the hearing examiner got that paper. So, my overarching argument is that it's so attenuated. What the boy and the grandmother reported from what the hearing examiner had in front of her. Again, the statements and, consistency, detail, circumstances under which it's made, those are all the indicia of reliability for hearsay issues. But in this case, the boy's statements were inconsistent. I mean, if you look at all of the DCF records, he made inconsistent statements for years about his parents, about what was happening at home, and in fact,
Doesn't that go to weight, not admissibility?
well, I believe, yes, it does, but it also goes to reliability. It also goes to whether the hearsay in these reports, what the hearing examiner is reading, whether that is substantially reliable. Enough to find by clear and convincing evidence that he's a highly dangerous sex offender. Because this was the reason this sort of brought the reclassification hearing, was these allegations. And
Aren't there cases where we have held and the SJC has held that hearsay along the lines that was admitted in this case is or may be reliable depending on a finding of the hearing examiner?
Sure, but
we may not like that rule, but that seems to be the rule.
right, and I'm not arguing that but what I'm arguing is in this case, the reliability in this case, and there is case law that says, and that we cited in both of our briefs, it's cited in the hearing examiner's report, the detail in the hearsay, the circumstances under which it is made, any kind of corroboration. I'm sorry, I don't have I don't have the in front of me. It's case 103400. But so that's the examination that's what the hearing examiner has to look at. And the hearing examiner said that it was detailed enough and it was plausible. And I'm arguing that finding was incorrect.
Does it matter that there was more than one source of the information?
There was the grandmother
Right.
who reported it initially. They did bring the boy in for a SANE interview that was observed by a lot of people. And if you read what the grandmother said and what the boy said, she had much more detail. And I would argue again, in the red brief, he says, that the grandmother corroborated the boy, and I think it's just the opposite. The grandmother made the first report. They brought the boy in. He gave very little detail in his interview, and what we have from that is a summary of it that someone observing it wrote down on a piece of paper. And again, I suggest that is so attenuated that we can't even rely on that. But even so, it was what the grandmother said. And we do have an affidavit from what she said, but again, we don't have any transcript. We don't have an actual transcript of her interview. And we have other details. We have the boy denying several times to treatment providers that he hadn't been touched inappropriately. We have he was a little confused about whether it was in the living room or in his bedroom. He knew the details about his house, but he didn't have a lot of details about the actual sex offense that he was accused of. And again, the lack of cooperation, I think, is really important here. The final piece is and again, it's not the delay. The Commonwealth seems to argue in the red brief that the delay wasn't improper. And that's not the issue. The issue was the motivation of the actual first reporter, the grandmother who, the circumstances under which she made the allegations, or she reported the allegations.
Didn't the hearing examiner consider that, though?
It did, but again, as is argued in the brief, that the hearing examiner decided that the grandmother had no motivation to lie, and I suggest that that's just conjecture, and it's based on what the hearing examiner's experience, her own experience with DCF was. So because of her own experience, and those were facts that were not in the record, and again, that it's inappropriate for the hearing examiner to make considerations about facts that are not in the record. she said, and so she basically, the facts that were in the record was an affidavit from the care and protection attorney talking about it. And she rejected that based on her own information, not based on what she thought was credible or not credible about the affidavit. And again, and the hearing examiner ignored all of the animosity between the grandmother and the father, which is another, you know, she's over and over, if you read in the DCF records, there are many times that she's complaining and she's like, he shouldn't be with children. He's a sex offender. He shouldn't be with children. And then there were several affidavits that also suggested animosity between, so whether or not it was exactly the custody issue at that very moment, it was clear that there was animosity and that the grandmother did have a motivation to lie. And and I think the hearing examiner was incorrect to find that, to speculate that based on her own information and not actually considering what was in the record. So again, this is, I mean, there was domestic violence in the house, but again, if you look at the DCF records, none of the violence against the boy was substantiated against the father until the very last time. And every single time DCF came, they substantiated neglect and abuse from the mother, but not the father. And he did have custody up until the last time. The issue really was. And I'm not arguing, I mean, domestic violence is harmful to children. I'm not arguing that, but there has to be a nexus between the defendant's behavior and whether or not he's sexually dangerous, whether or not these empirically validated risk factors apply to his behavior, if there's some kind of a nexus. And I'm arguing that all of this, there's really a lot of smoke in this case. There's not so much fire. There was, the police responded, both parents seemed to have gotten arrested, the charges got dropped. There was a lot of volatility in the house, but it wasn't until that very last time when the child was removed that DCF finally substantiated abuse for the father because he kept letting the mother in the house and she wasn't supposed to be there. But again, it wasn't about, and even after that, the boy was interviewed after he was taken away and he said that no one touched him inappropriately. Not until 6 months later when the grandmother made these allegations. So, I mean, that's my argument. It's simply not enough. It's not enough reliable evidence if you take all these layers of totem pole hearsay.
So I'm gonna raise something that isn't in either of the briefs, but when we have cases that usually this reliability of hearsay comes up in probation violation cases, and it's the the probationer is charged with a new crime, and it's based on the police reports. If the defendant is later convicted of the crime, that sort of issue becomes moot in terms of whether there was a basis to revoke probation. Correct me if, and we can take judicial notice of related cases. Correct me if I'm wrong. I believe your client was convicted of this act?
Well, it is not in the evidence in this
No, I know,
this hearing.
but we could take
And
judicial...
it doesn't, sex offender registry classification is based on current circumstances. So this doesn't, so what happened at this hearing doesn't get negated by anything that happens afterwards.
So, am I correct that he's now incarcerated on those charges?
That is my understanding.
And does that affect his? Is he required to register at this point?
Well, no. I mean, no one in prison has to register. It's too dangerous. So that changed, and he's not on the registration. He will if he's free. But let me just say that in this, so this was decided.
I appreciate that we can't say it's reliable because of that. I understand that.
Even with conviction, so even if he gets convicted, even if he spends time in prison, his circumstances the next time are going to be completely different when he's in front of the SOR board. However, he'll be older. He will may or may not have had treatment. So I mean, this is based on what the condition he's in currently.
Is this moot though? Is it moot?
No, Your Honor.
He's not required to register at
No,
this point?
because the SOR has to, they're mandated to classify people before someone gets out of prison. If this stays, if this gets upheld, the minute he gets out of prison, he's a level 3, and then he will have to go himself to ask for a reclassification. If this ends up being remanded, then he will get a hearing 6 months before his sentence is up, whenever that is, based on his current circumstances. So no, this will not be mooted.
Okay, how about the other thing? You make an argument about public place. What is the definition of a public place?
Well, you know, it's I think the SORB's definition is a place where a person could be open to being discovered. So it's not exactly the legal definition of a public place in the statutory legal definition of a park or so it's if you have an expectation of privacy or an expectation that you'll be, that somebody will observe you. And again, I would argue, number one, in the first crime, they went into the woods, took a walk in the woods and found a hut and went inside the hut. And I mean, I would argue that that's actually looking for a place that you won't be discovered. But in the second...
Is there any evidence in the record about how far the hut is from the road or anything like that?
No. And the second one, he was in the living room of his own house. Only he and the child lived there. So I mean, maybe if there were other people in the house, the living room might be a public place, but he lived there by himself with his child. So again, finding that the living room was a public place was just incorrect. And I believe that factor was misapplied in this case.
Okay. And what do you say to the Commonwealth's argument, or to SORB's argument, that you actually can consider the dismissed cases as part of the entire criminal history?
Absolutely. Again, the issue is the reliability of the evidence. It's admissible, the SORB can consider it, but it has to be reliable. It has to have substantial indicia of reliability in order for the hearing examiner. And in this case, we argue that the hearsay was not substantial, and certainly not substantial enough to find by clear and convincing evidence that he's a high-risk, highly dangerous sex offender.
Okay. Thank you very much for your argument.
Good morning. May it please the court. My name is Stephen Killey, and I'm here on behalf of the Appellee Sex Offender Registry Board. I'll echo that Attorney Schnei is sorely missed in our office, and he was a wonderful human being, and we appreciate counsel's comments. Turning to the arguments in this case, there's two things I want to address first, and that is that while there might not be a direct transcript of the forensic interview of the complaining witness, the boy referred to in SORB's brief, there are direct quotes contained within the police reports as well as in the DCF records. And it's clear from the police report that there was a DVD that was taken of that forensic interview and is referenced in the police report. And there's no suggestion here that there was any reason or motive to fabricate the quotations that are contained in the police report or the quotations that were contained and taken from the boy in the forensic interview that was witnessed by professionals not only from the district attorney's office, but also professionals from the police department as well as the forensic interview staff.
Is there evidence? Did the hearing officer review the DVD? Or just
no, but I think it's fair to infer that she could substantiate and find by preponderance of the evidence that the quotations that are contained in the police report were verbatim or at least a summary of an accurate account of what the boy communicated during the forensic interview with law enforcement. I think that what my sister calls inconsistencies in the boy's telling of events, I would, as Attorney Schnei argues in SORB's brief, I don't think that there are any inconsistencies. There may be a telling of events to the grandmother that was maybe greater in detail, but nothing about what was told to the grandmother and then later told to law enforcement is inconsistent. You have, again, just more information. And the information that was told to the grandmother essentially was that he could not perform the task that he was being asked to do by his father without stopping because he was gagging on his father's penis. And therefore, it's not uncharacteristic of a child, now age 7, when this occurred, he was age 6, to not have a fresh recall of every specific detail. But what's important to consider is that what was entirely consistent was that this occurred in the living room, that it occurred while the father had put on an erotic movie and that there was a woman performing a fellatio on a man. These are not concepts or ideas that an otherwise 6-year-old would be familiar with or a 7-year-old would be familiar with. And I would submit to you that the naivete of the boy kind of further substantiates and corroborates exactly what he's communicating. Even when he does his first telling of the events to the grandmother, he does so in a kind of spontaneous fashion. He doesn't do so in response to any kind of interrogation. The grandmother was kind of forthright with the therapist and then later with law enforcement. And again, it's also important to consider, while there's no direct transcript of the grandmother's interviews, she does give a written statement, and that in her own hand, and that written statement is part of the record before the hearing examiner and before your honors. So in that statement, and as she told to investigators, she was somewhat appalled by what she was told by her grandson. She admittedly did not react the best to it, calmed herself, and then asked follow-up questions. So while there were some questioning of the boy during the first telling, it was not in it was not done in a fashion as an interrogation. And there's two distinctions to make when it comes to the grandmother. First, she's not the victim of the crime. There's an independent basis to find that there were credible allegations made by the boy, or victim 2 in this circumstance, because one, he told the grandmother, that was told to the therapist, but then he independently told that information to law enforcement and sat down for a sane interview.
That was about 11 days after he told his grandmother, is that
That's correct, Your Honor. I believe that the initial allegation was made on or about August 6th, and then August 16th is when he sat down with the forensic interviewers. And notably, as is the case in most forensic interviews, and as the hearing examiner and the board is obviously well aware, the second interview that was done with the boy was done in such a way as to not introduce leading questions, to not introduce evidence that would not necessarily be readily knowledgeable to the boy. And what did we have? We had the boy essentially giving an almost identical recitation of what he had to perform on the petitioner, and that the fact that he was asked to fillet this person, described the fact that there was an erotic movie that was put on, and was very clear about where that took place.
I have a question about public place, which is not really addressed in detail in your brief. I can understand why the hut might meet that qualification. Why does a living room qualify as public place under the regulations where just Doe and the boy are there?
Thank you, Your Honor. I don't believe that the application of Factor 16 was predicated at all on any conduct involving victim 2. Really, the way I read the decision is that Factor 16 was applied based on the conduct involving the first victim. The fact that, especially on the second encounter with victim 1, that that encounter occurred in an abandoned hut in the woods, and that certainly was not a place where there was an expectation of privacy of the petitioner in that location. I would add that the record evidence supports the fact that that was a location where there was a public road that they met up near, the fact that the victim described it as a hut that was in the woods and frequented by teenagers, and therefore I would suggest to you...
I hear you. I'm looking at Record Appendix Volume 4, page 88. Petitioner sexually assaulted victim 1 in a makeshift hut that he found while walking with her in an area where he had no expectation of privacy. He also sexually abused victim 1 in the living room of their home. So maybe my question was inartfully phrased, but
No.
I thought that second incident involved a situation where just the victim and Doe were in the house or lived in the house or apartment. Am I incorrect?
Oh, it weirdly says victim 1. Is that
Right. Is that a typo or?
My memory of the decision was that it was largely predicated on conduct involving victim 1. I think that if, to the extent that there is language under Factor 16 involving victim 2 or the allegation that there was conduct that occurred in the living room, if no one else was present in the home, and I think my memory of the record is that the boy testified that the mother was not home at the time and it was only the boy and the petitioner, I would argue it's a scrivener's error. And in the event, I don't think that it affects the factors application, and therefore I would suggest that any error in applying that to the lens of conduct involving the boy would be harmless. Because
Just to be clear, whether it was victim 1 or victim 2 in the living room with Doe, there's no claim that there were other people in the house at the time, correct?
No, I think that if there was evidence in the record that there were others home, then obviously there would be potentially sufficient evidence for application of the factor based on that conduct, but as you're identifying, that's not the case here. So,
Is there evidence that there was somebody else who had access to the house? I understood Attorney Rose to be saying that it was that Doe lived together only with the son, but you just said that the mother also lived there.
well, I didn't say that the mother lived there. I said that the mother did have access to the home, and the boy testified the mother was not home at that time. As is clear from the DCF records.
So not home at the time suggests that she would be home at other times. I mean, does she live there or not?
My understanding of the DCF records is that she did not live there, but
Okay,
that
okay.
she gained frequent access to the home despite there being a DCF order that she not have contact with the child.
Okay.
I would echo that I would submit that Factor 16 is nonetheless applicable to the present case based upon that conduct with victim 1, and that any application of that conduct with respect to victim 2 would be harmless. So just touching on the other hallmarks of reliability of victim 2's statement, I do think that you have a consistent telling of events across multiple tellings. I think that you have the naivete of the boy in describing the conduct. I think that further substantiates his telling of the events. I think that the hearing examiner did evaluate the motive of the grandmother to essentially drum up these allegations. I think while she did kind of go in and delve in onto her personal experience as a prior social worker with DCF, I think there's two things to say about that. The first is that she also found an independent basis in the DCF records to disagree with the care and protection attorney, and that's Attorney Mahoney's affidavit. She noticed that the DCF records conflicted with the Mahoney affidavit in a significant way, and the first being that DCF indicated in the records that they maintain custody of victim 2 through the care and protection petition. That obviously was different from what Attorney Mahoney was claiming, and that the grandmother was in this kind of entirely different review process outside of the kinship placement. One thing I noticed in Attorney Chenai's brief, in the SORB's brief, obviously I don't want to take an inconsistent position, and he claims that it was improper, or may be improper, for the hearing examiner to consider that personal experience as outside the scope of the record. However, I would just point the court's attention to a footnote in a concurring opinion, and I believe it is in Doe 89230 v. SORB, that's 452 Mass 764, 2008, wherein Justice Spina does state that although an agency may not use its expertise to build a case for or against a litigant, it may apply its expertise to evaluate the evidence. And there's a citation given in the footnote. And I think that that's important and relevant here because the hearing examiner did not utilize her expertise with a DCF to essentially build any kind of particular case against the petitioner here. Rather, she just relied on some of that personal experience in finding there to be inaccuracies in the representations that were made by the care and protection attorney in the affidavit. And therefore, I think that it was rightly for her to consider that. I think that it would probably be not in the judicial economy for her to be ignorant of any kind of personal experience that she may have and bring to the evaluation of evidence, and that that would not serve the board. Moreover, I would submit that my sister indicated that the hearing examiner's findings with respect to the motive and there being no motive to lie, she calls it conjecture or speculation. But I would submit that the attorney affidavit submitted by Attorney Mahoney was largely conjecture and speculation. There was no other evidence in the record to support an allegation that the grandmother had any motive to lie or to fabricate these allegations, and they're entirely consistent with the representations made by the boy during the forensic interview And unless you have any additional questions, I would.
I do. I raised it with Attorney Rose. The fact of the subsequent conviction and Doe being not on the street anymore, does that moot this, or will the level 3 classification come back up whenever he's released?
I agree with my sister counsel that it doesn't necessarily moot the issue. Obviously, at the time that the hearing took place and the record that was before the board, that's when the decision ultimately was made regarding the level 3 classification. I would not only urge you, but I agree that there should be some judicial economy and judicial notice taken of the fact that the petitioner was subsequently convicted for this conduct, and that.
I mean, what I'm asking is, if we're going to issue a decision that affirms or reverses the classification, is that going to have any effect in the world?
The effect of a remand would, I believe, essentially, he would be remanded for a further analysis consistent with any remand order. And then, obviously, due to the length of incarceration that he was subjected to, that my understanding he was sentenced to 20, 25 years in state prison, that since the other case law essentially says that the final classification has to take place close in time to any potential release, that would be delayed and the decision would essentially default to the level 2 that he was already classified as, and then any reclass would be placed into a kind of a provisional status. If you were to affirm the reclassification of a level 3 decision, then as my sister stated, he remains in an incarcerated status, and it's hard to say exactly when his release date would be, but the board obviously understands its obligation to have a current classification. Nonetheless, I would submit that that level 3 would be active upon his release, unless and until a new classification hearing was held.
In either case, affirm or reverse, any subsequent hearing is going to be based upon all of the factors and facts that exist at the time of the next hearing, correct?
Yes, Your Honor.
So, okay. Thank you.
Thank you.
Okay, thank you both. The case is submitted. We are now going to take our regular recess. We'll be back at about 11:15 to hear the DCF case.
session, please be seated.
So, back on the record for 25P465, Department of Children and Families versus Father. Again, reminder, it's a impounded case, so no names, refer to father, child, etc. And I also, we had a call from counsel for the child yesterday, who was unable to appear for argument and ceded his time to DCF. So that was with the consent of the child. The child is not here. Child's counsel is not here today, but consents to going forward. So with that, Attorney Grantham O'Brien.
Good morning, Your Honors. Tamika O'Brien on behalf of the appellant father. Your Honors, this case presents a disturbing pattern. DCF failed its statutory duties, created evidentiary voids, then relied on those evidentiary voids to justify termination, and the trial court endorsed this without scrutiny. From prison, father did everything he could. He immediately sought paternity.
But he didn't immediately seek paternity, did he? I mean, how long did it take him to have the swab?
I'm not entirely sure how long it took him to have his swab, but DCF didn't have the child swabbed until June 3rd of 2024. So,
Never raised that as an issue of delay to the court, did he?
no, but the trial court inappropriately assigned that delay to father. So there was a delay, but father came forward as the possible parent from August 2023, and so DCF a month later, in October of 2023, changed the child's goal. So 4 months into the case, changed the goal to adoption. In December of 2023, paternal grandmother was, so father, before he had identified paternal grandmother as a potential kinship placement, father asked for visits. The court investigator interviewed grandmother.
Where is it in the record that he requested visits? You mean with the grandmother or with him?
I'm sorry?
He requested visits with him or with the grandmother?
I apologize. I'm not entirely sure if he requested visits, but that does not shirk DCF's obligation to provide him with visits. There's their own...
Well, the statutory or the regulatory, the obligations for parents, right?
Correct.
And when was he adjudicated a parent?
He was adjudicated parent late June of 2024.
It was actually September, wasn't it, the last day of
Well,
trial?
yes, but I'm sorry, the DNA confirmed his parentage in June of 2024. In September of 2024, he was adjudicated the parent. So regardless of the semantics involved of the parentage, DCF had an obligation to provide visits.
It's not semantics when you say they had an obligation in August of the prior year.
They treated him as if...
An obligation, and he hadn't been living with a mother, he hadn't met the child. I mean, what exactly was their obligation at that point?
Their obligation says that they have to, there's special efforts they have to take for incarcerated parents. And even though he was not, paternity was not established and he was not adjudicated, he was still treated by DCF as the presumptive parent.
Well, he wasn't given an action plan, was he?
Correct. He was not given an action plan because DCF says we don't have to give an action plan if the parentage has not been established. But they still, everyone involved assumed he was the father. And, you know, DCF in testimony says, I tried to reach out to him in prison a couple times, worked through his CPO, wasn't able to reach him. That's no excuse. You can call the prison. MCI Shirley has a Zoom set up. It is an easy thing to do. You call the prison, you say, I'm social worker, I'm the attorney, I need to speak with this person, and they schedule a Zoom. So, and she could have gone. There were plenty of opportunities here for father to be engaged, whether formally or informally. But what happened here is father's in prison, he's very easy to ignore, and they find a very nice family for this child, and that was it. It was that quick.
To what extent were these issues raised at trial?
Well, Your Honor.
If at all.
Sure. So, and this is part of my...
I understand. Let me preface this by saying I understand that part of your argument is perhaps some of this comes to light in some sense later on. the facts existed, but maybe the argument didn't exist
Correct.
or wasn't thought of. But still, we need to know to what extent this was raised before the trial judge, because we, as an appellate court, are really not equipped to deal with this in the first instance.
Sure. So, Your Honor, in this situation, Father argues that he was denied a fair hearing. At the June 2024 trial, the court said that we're going forward on mother. The child's counsel said also we're going forward on mother, hold off on father. So 3 months later, father's trial occurred. So father did not...
Can I just clarify something? You were talking about the June 14th. In your brief, you say that he wasn't present, represented, or permitted to participate in that first hearing. But in fact, he was present, was represented, and his counsel did cross-examine, at least was given an opportunity to cross-examine all the witnesses and cross-examine one of them. Isn't that correct?
That is correct. He was present, and I apologize for the mistake in my brief that he was present. However, everyone in this court knew that this was mother's hearing, and this goes back to, you know, in June, it's mother's trial. They're going to hold off on father. In September, we're at trial for father, and the father's trial counsel attempts to call DCF witness, and the trial court says, oh no, DCF's arrested, you had your opportunity, when in fact, that's not how anyone saw it. Father's counsel believed that that was mother's trial. And this case is very analogous to adoption of Adina, which in that case, DCF witnesses testified at the other parent's trial, and the court in that case vacated the termination where the parent couldn't cross-examine DCF worker who had testified in father's trial. In Adina, it was mother who was seeking, sorry, I don't want to get too confused here. In Adina, it was mother who was in father's position in this case. Mother was not present for father's trial. Here, father was present, but all parties involved here were under the understanding that this was mother's trial, not father's trial.
So then at the father's trial, as I understand it, on appeal, you're making in part the claim that at father's trial, he could have called DCF again to the stand. Is that right?
Correct.
But yet I see father's counsel saying, it's volume 1, page 30 of the transcript, he ultimately says, so I don't have a need for further questions of the department.
Not at that time.
Okay. Is there somewhere later in the transcript where he preserved an objection to his inability to call the department again?
Your Honor, a due process violation of this magnitude, denying the right to confront the witness can't be waived, and so we're
I
arguing...
understand that, but you have counsel making an affirmative representation to the judge that I don't need DCF as a witness. So due process provides him the ability to call in witnesses if he so chooses. Here he advised the court, I'm choosing not to. I don't need it.
I disagree with the assertion that the trial counsel said she did not need it. She did not have questions at that time. I think that she was maybe a little thrown off that we're in trial for mother's trial and then...
I don't have a need for further questions of the department. That's what's in the record before us. Counsel made objections in the record. She was more than capable of coming back later and saying, you know, Judge, I've thought about this and I do have an objection, and I don't see that in the record.
Your Honor, adoption of Adina is instructive here. The court in that case granted relief despite no objection, despite no, this particular words. In that case, the court explicitly also said that the case was against, or in this case, the court explicitly said that this proceeding was against mother. And father had no reason to believe that his trial, requiring full participation and confrontational rights, was not going to happen. That's what occurred here. It was mother's trial. 3 months later, DCF still had not done any of its statutory duties, still had not reached out to grandmother to assess a kinship placement, which is required under their own statutory guidelines. They had not reached out to father for a visit. They had not reached out to father for an action plan. There was 3 months, they could have done something. So this can't be placed all on father, on his blame. We go to trial, and then there's no evidence. There's no evidence of grandmother's suitability or unsuitability of her kinship placement.
But
There-
she didn't appear, correct?
Sure, she didn't appear, but DCF still failed in their obligations, their statutory obligations. They knew since at least December of 2023 that grandmother was a kinship placement. The adoption of Elion says DCF has an affirmative duty to assess known kin before seeking termination. They knew in October 2024 that they intended to terminate the parents' rights, and they changed the goal for adoption. And then, so fine, maybe they don't know in October of 2024, but they knew in December of 2020, I'm getting my dates confused, I'm sorry, Your Honors. In December of 2023, they knew grandmother was a possibility. The court investigator wrote in her report that grandmother was interested and made recommendations of services that DCF could provide to father. They didn't. They looked at him as a non-issue because he was incarcerated. And
Well, he was incarcerated and he was not.
I'm sorry?
He was incarcerated and hadn't been established the paternity yet.
correct, but he was incarcerated at the time, and they knew he was incarcerated. But that doesn't mean that they don't have affirmative duties to treat my client as if he were like any other parent. They assumed he was the parent. Again, they didn't do any of their statutory duties here, nothing. They didn't even go out to meet him at the prison. They didn't go where he was. DCF goes and does home visits with the parents monthly, but they didn't do this. So, Your Honors, at this point, I think that the violations that occurred here, both on the statutory duties that DCF had in not servicing father properly, not providing visits, not assessing kin, not even, then they go to court and say, oh, well, father doesn't have a bond with this child, so termination should apply here, and also that parent should have no contact or visits going forward. Adoption of, I believe it's West, says you can't put up a guardrail or a fence and then later on use that against the parent to establish.
I noticed that quote from Adoption of West because I wrote Adoption of West, and that quote's not in it, and the citation is wrong too. Could you do us a favor and write a 16L letter, tell me what actually where that quote comes from?
Yes,
Because
sir.
I couldn't find it.
Okay, yes, sir. So again, at this point, father's not necessarily asking that the child be removed and given him custody, but he is asking for his statutory rights under DCF obligations to be fulfilled and to have a fair opportunity for a fair hearing. Your Honors, if you have no other questions, I will rely on my brief.
Seeing none?
Thank you.
We'll hear from DCF, Attorney Cuddle.
Good morning, Your Honors. Can you hear me okay?
Yes.
First of all, I apologize for the delay in my appearance earlier.
Oh, no worries. Understood you're indisposed at the moment.
It's the first time that happened.
It happens.
William Cuddle for the Department of Children and Families. We're asking the court to affirm the decree terminating father's rights and allowing this child to be adopted by his pre-adoptive family. Your Honor, I know you've read all the briefs. I'm here to answer questions, but before I do, I just want to point out that my sister makes assumptions both here and in the brief that are not part of the record. And there were no delays of the department in the paternity matter at all. Clearly, I set out in the department's brief, father was appointed attorney in November of 2023. To his credit, he wanted to pursue to see if he was the actual father of this child. But you'll see that with all the motions that were filed, the first motion that was filed related to a continuance in paternity was not until March Father had the obligation to establish his paternity. He waited at least 4 months. The record doesn't say why, but there was another hearing on the 21st before the trial on the 22nd, where he made the decision with counsel to seek a third-party company that does paternity testing, which was his choice to do. None of that is the department's fault.
Is paternity testing like that at the expense of the putative father, or?
Say that again, Your Honor?
Is paternity testing at the expense of the putative father in these cases?
Yes, the parent has to go to the Department of Revenue under the statute. I think it's 209. What the department's obligation is to make the child available once the third-party vendor is available to do the testing, which the department did on, I think it's June 3rd or June 4th. Father was tested later on that month. So I don't want to belabor the point because some of what happened is not Father's fault. You know, I guess his first vendor was not available and had to get another vendor, but to make the assertion that Father made in their brief that somehow this is the department's fault is not based on evidence in the record. This is an unfortunate case of a father who, as the court found, had made the decision to get involved in a criminal life for a substantial part of his adult life, had been incarcerated several times, was incarcerated throughout the whole life of this child. The department, under its regulations, is not required to provide services to a person who's not legally identified as a parent for obvious reasons.
Counsel, your sister cites, I think it's Talib, similar in that I believe the father hadn't been established yet, but the department in that case, it's an unpublished case, so
yes,
maybe it's a hypothetical scenario. The department did offer an action plan of sorts, though.
They did, Your Honor. They made it.
Was it discretionary if someone paternity hasn't been established for the department?
I think it could. I don't know if I'd use the word discretionary, but yes, it is discretionary. I guess in that case, I read the case last night in preparation, and the circumstances were a little bit different in that case, where it was more clear that the father in that case was more. There was more of a presumption that he may have been the child's actual father. But I looked at the dates, and the case went on for a long period of time because I was during the COVID period. Father was actually, his paternity was established in September of, I think it was 2022. And the trouble that the trial judge had was with the department's efforts after that fact, because Father had not wanted to have visits, his choice, didn't want the child to have to come to prison. But when he did actually ask for a visit, the social worker testified that clinical decisions had to be made about that issue, which I can tell you under the regulations that, you know, the department does try very much to follow its regulations. And under 110, Section 110 and 110, Section 7.128, I believe.
Under our case, when did those regulations come into play? When the test
Say that again? I'm sorry.
No, I'm sorry. In our case, when did those regulations take effect? When the test established 99.99%?
No, they take effect when the child's adjudicated, and the child was adjudicated on September 12th. So the information came in, I believe there's some information in the record that it came in sometime in June. The paternal grandmother was given a visit in July, technically not adjudicated, but the department offered her a visit. But there's no evidence that we didn't offer Father a visit at that time, and I'm not sure why. I don't know if it hadn't been set up yet. Father was in prison. I will say this, because I don't want this to not be mentioned. The pre-adoptive parents in this case, who did a wonderful job taking care of this child with their special needs, made it very clear throughout their testimony. And they testified, one testified on one day, the first day of trial, and I think the pre-adoptive mother testified on the second day of trial. They're very open to contact with both the maternal side and the paternal side of the family. Now, that's not something that the court made an order about, but you don't always see that in these cases. I think it's important for the court to take mention of that because it's in the record.
Counselor, on the kinship placement, I'll just summarize. Well, you heard your sister argue that DCF's efforts towards a kinship placement were insufficient, but you referenced the visit. The visit may not have gone very well, but maybe it's not uncommon for a child to cry. But what would you say about the department's efforts with a kinship?
The department's efforts in this case were limited based on the circumstances, and that's acceptable under WALT. I would point the panel to the transcript after I think it was, I'm not sure whether it was the first or second day of trial. The trial attorney for the department did inform the court that they were under obligation to investigate the paternal grandmother, and they were in the process of doing that regardless of what was going on with the case. So that process had started, although, albeit it was not until August, a month before the last day of trial. So they were beginning to look into the grandmother. But as you pointed out, Your Honor, grandmother didn't come to trial on the last day. And the notion, before I forget, the notion that there wasn't a fair trial here, the department didn't make reasonable efforts. The department did make reasonable efforts. Even if the department didn't, under these circumstances, it would not make a difference based on the factors in this case. My brief sets them all out. I'll be happy to answer questions about that. And as far as the trial is concerned, Father raised no objections. This idea that it was two separate trials is not based on the record whatsoever. Father had an attorney on the first day. Everyone came to trial on the first day. What happened on the first day is Father filed a motion Father's attorney filed a motion to keep the evidence open because he wanted to make sure Father could be adjudicated, because at the time of the first hearing, Father's goal was to at least put a competing plan in place with his mother to take care of the child. And in order to do that, he needed standing. So the court left the evidence open. The trial was not limited to mother only. The evidence was entered. It was a short case. It's a brief case, as you're well aware. The court investigation report came in that had a plethora of evidence about Father. The DCF report came in. 3 witnesses testified. As the court pointed out, Father's own attorney cross-examined the ongoing worker about issues related to communication with Father, had nothing to do with Mother. And then afterwards, at the end of all the 3 witnesses, the court asked both Father and the child if they wanted to call any other witnesses at that time. They both declined. The court said it was going to suspend the trial and continue it till the next day, and that's what happened. So there were no 2 separate trials. On the second day, additional exhibits were entered, and everyone had an opportunity to participate in closing argument. So if you have no other questions, I'll
I just have a follow-up on one that Judge Smith asked. Is there a policy or a CMR or anything about the services that have to be provided to a putative father who has not established paternity? Or is it discretionary?
I don't know the exact answer to the question, Your Honor. I think I cite in the department's brief to 209C, I think it's subsections 1 and 5 that have to do with presumed parents, and there's characteristics that the court considers to determine whether they're presumed parents, which I would assume that means, without knowing directly, that they would be given some more opportunity for involvement with the department. But I can certainly follow up with a letter to you if you'd like me to. I just don't know the exact answer to the question.
No, we don't need a letter on that, but.
You don't need a letter on that?
All right.
Clearly, do I have a couple of seconds, or am I out of time?
You've got 4 minutes.
Oh, thank you. These cases are very difficult, as you are all aware, but we shouldn't lose sight of the fact that the child in this case is doing extremely well, and due to the efforts of her pre-adoptive family. The father Oftentimes in these cases, fathers get vilified if they're incarcerated. That wasn't the case here. Everyone treated father well. You can tell through the transcript, even though it's short, how people were talking to the father. He did try to establish paternity, but he just took too long to do it. And quite frankly, given the circumstances of this case, given the fact he was incarcerated for an extended period of time, given the fact of his child's special needs and the fact that he gave no testimony about how he would take care of that child himself other than to have his mother do it, who didn't show up. It's just an unfortunate circumstance. But the trial judge made the correct decision in making the decree enter for terminating his rights and setting this child free for adoption. If you have no other questions, I'll rely on the department's brief. Thank you.
We don't. Thank you. Thank you both. The case is submitted. And our last one for this morning, still this morning, is 25P920, Gallagher versus City of Boston. Just a second. Okay.
Good morning, Your Honors. Still morning? Just barely, yes. Good morning. Thank you for the opportunity to argue here today.
I'm going to have to ask you to speak up a little bit, please.
Certainly. My name is Lena Kate Ahern. I'm Assistant Corporation Counsel for the City of Boston. I represent the City of Boston. As self-insured for workers' compensation, we are the appealing party in this case. While the facts in this case are factually quite complex, the issue that we have raised on appeal is in a way narrow and simple. It's that there was not sufficient medical expert opinion evidence in this case to sustain the employee's burden.
Let me ask you a preliminary question. I don't think it's in the record. Did the parties file a Form 140 conference report in this case?
I believe so.
In that Form 140, did they agree upon the impartial physician?
I'd have to take a look. I could pull it up.
Not going to ask you to use your time for that right now,
Okay.
but no, you may not, don't. So that's my first question. I guess my follow-up then would be whether or not they agreed on the, the form asks if there is agreement, name of the impartial physician, and the medical specialty of the impartial physician. Was that delineated in the Form 140, and was it agreed upon?
I couldn't speak to that, Your Honor.
Okay.
But I can certainly look into it if the court would
Okay,
like.
well, perhaps Brother Counsel can answer those questions when it's his turn.
I will note that a Section 11A motion was filed by the City of Boston, noting that the case was complex and that an orthopedic
You wanted to submit your own, I won't call them experts, but your own record reviews.
Right,
And that was Doctors Ibrahim and De Silva?
correct.
Out of curiosity, so neither one of them would have met with the plaintiff in person, correct?
Correct.
And did either one of those doctors, had either one of them done research on, and if I'm mispronouncing this, please correct me, Cauda-Equina syndrome?
The syndrome, it's Cauda-Equina syndrome, so Cauda-Equina is the area of the nerves at the bottom of the spine.
I understand what it is, I just can't say it.
Yes,
But had
understood.
either one of them done research on that?
Yes, and I believe it's in Dr. Silva's report. I can't speak specifically to Dr. Ibrahim, but I know Dr. Silva talks about specific cases and studies that he reviewed regarding this particular type of very rare spinal cancer causing Cauda-Equina syndrome, and also pointed, I think, to specific symptomology that was present in this case that is present in the
Had he researched it himself, or he had just sort of read about certain studies about it?
My understanding, I believe, was that he had researched it and was familiar with the research that was done.
Had either of them ever treated a patient with that type of lymphoma?
I don't know that either of the doctors...
Understanding that it's not your burden in any event, but I'm
Yes.
just curious.
Yes, I'm not aware of whether either of the doctors that did our records reviews had treated patients with those issues. I don't think that was addressed in their report, but I know Dr. De Silva did talk about very specific research and symptomology shown.
Thank you.
Well, we're on that subject. So at the deposition of Dr. Morley,
Yes.
your colleague asks him, if there hadn't been a back injury and there was just a lymphoma, is it possible that the same progression of symptoms would have happened? Mr. Sullivan objects, says, that's not the right standard, but says the witness can answer. Witness answers, I don't know. But so, was he right about that? What is the question, would it have happened even if there has an injury? Is that relevant?
I would think that it is relevant if something would have happened regardless. I don't know that the event in question could be considered to have caused it if it was going to happen regardless of that lifting event.
But I mean, when the doctor says, I don't know, but in my opinion, the injury was a major cause of it.
Yes, and that was the doctor's opinion, and for all the reasons we've outlined in the brief, we think that that opinion is flawed and incorrect, and falls sort of outside of the bounds of reasonableness, even within the deferential standard to the administrative judge, that it was not reasonable to adopt any of his opinions, given all the problems with his analysis, his account of the facts, et cetera.
And just a legal question too on this. So I know for a number of reasons you say that opinion is wrong, but if he's correct that notwithstanding the pre-existing lymphoma, the work injury is a major but not necessarily predominant cause of the injury, would that be legally sufficient to put the city on the hook for? I know you don't agree with that, but if the conclusion is correct, is that?
Yes, and I came into this case later. It didn't appear that Section 17A was raised. Section 17A applies a slightly heightened standard, and the doctor actually uses the language necessary to meet that heightened standard. I don't know that it was necessary in this case. The basic standard is a simple but-for causation. But yes, I mean, that statement is correct, and in the report it says this was to a reasonable degree of medical certainty. Where the problems come in with respect to the substance of the opinion itself is, all the issues that we've raised. And then the certainty issue comes into question during the deposition when he starts to be challenged on some of these issues in terms of, different locations of the spine, differences in what the surgery that the employee had was actually for. That he begins to say things like, somehow, I'm not sure how, but somehow I think this caused this, and that's simply not sufficient for a medical expert, particularly given the complexity of medical issues in this case.
How do we get to unreasonableness when we're talking about this incredibly rare lymphoma on which so little is known? They're still studying it. We never see it. Or so not never, rarely see it. I mean, it almost seems like part of your argument is, well, what he says is wrong. We can't tell you exactly what's right, but what he says just not good enough. Maybe it's right, maybe it's wrong, but it's not to a reasonable degree of medical certainty.
Sure.
I'm having a little bit difficult with that conceptually in the context of an arbitrary and capricious standard of review.
Right. So I think what's critical to keep in mind here is inaccuracies, contradictions. Those are sort of the key issues.
Sure, he does say he was out of work for 3 to 11 months when it was 3 to 4 months, and he's
vice versa,
wrong.
yes.
And he's wrong on a few facts. That I understand, and that's called good cross-examination. But I don't exactly see in the cross-examination that sort of defining, smoking gun moment where we say, "Oh boy, is he just wrong."
So I think the most critical issue here in looking at why I think, legal guardrails essentially on what doctors can and cannot do in these cases is that Dr. Morley was under the understanding, presumption, however you want to term it, that the treating physician saw compression in the employee's spine. Compression, I think, is the key word here to the critical flaws. Dr. Morley opined that he thought that the surgery in April of 2022 was a fusion, and in part, he spelled this out a bit more in the deposition, but done at least in part to relieve pressure on the employee's spine, that was part of the purpose of it, for treatment reasons as opposed to simply diagnosis. And if you look at the treatment records themselves, that is incorrect, and that's a critical difference. If Dr. Morley thought that Dr. Shankar said, I need to do a decompression on this spine because there is a disc issue protruding, putting pressure on the nerves, that says to Dr. Morley, Dr. Shankar saw this as a problem, saw a mechanical problem with the spine being partially at issue here. And that's supported further when Dr. Morley says, I think the cancer caused lesions, which, were never shown on imaging. If you actually look at the treatment records carefully, which I grant is difficult to do, I myself spent, I don't know how much time trying to parse through this story and did try to lay it out as best I could, that none of the doctors saw compression. And in fact, they state this many times. And that, in fact, when the biopsy was done in April of 2022, there's explicit discussion that the employee said, well, wait, no, I don't want to do the biopsy yet. I want to go see an orthopedic physician to see if, some sort of orthopedic issue can be fixed. And the doctor said to him, if you want to, but we really don't think that's a problem. We've looked at your imaging now over 14 months, and we see no evidence of a mechanical problem causing compression. I think there's a quote that is, employee, for whatever reason, didn't submit the first 6 or so months of treatment records, but they are summarized by the independent reports that we submitted. I believe this was, I don't know if it was Dr. Dorley, but one of the neurologists who treated the employee in 2021, he said, he has had progressive weakness in the more proximal muscle groups of the left lower extremity that would not be explained by L4-5 pathology, which is where the disc issue was shown. That was me adding that part. But the critical quote is here. The nerves are clearly sick, but symptoms do not correlate with the lumbar MRI findings. I see no indication for acute decompression of the lumbar spine at the current time. And that is consistent with Dr. Martinez's findings prior to this lifting incident. There was the incident in 2019 where he also had some back pain. And you can see from the records, again, uncontroverted and submitted by the employee, that Dr. Martinez treated the employee over almost a year, and he was puzzled, just like specialist after specialist was puzzled after February of 2021. He explicitly notes in his treatment records, I'm looking at the imaging, I'm looking at these symptoms, and they just don't match. There's something else going on here. So, as you had stated, it's not our burden to show the cause here, but I think we have shown it. There's a multitude of experts. In fact, all of the treating physicians that the employee submitted records of say to him explicitly, compression's not the problem. Spinal mechanics are not the problem. This cancer is what is affecting the nerves. The imaging talks about, signal abnormalities. I forget the term, but there's a word that in the imaging, they can see problems with nerve roots. They don't say it's compression, and in fact, they say there's an absence of compression, and that's what has puzzled everybody for so long. We paid this employee for the first year thinking this lifting injury was related. But then in 2022, turns out it's cancer, and everybody's saying this is not compression, this was not the lifting incident. You have this rare cancer. It's very unfortunate and sad for the employee, but it's simply not connected with the lifting incident. But again, it is the employee's burden to present competent medical evidence. The case law provides a number of different factors that are important to look at. I think they all boil down to just sort of a reasonable analysis of what is competent expert evidence. And in this case, it's not that there's one particular issue or one particular type of issue. They're all present. So what we have here are inaccurate facts, both about symptom progression, and I would submit that being out of work for a year versus a couple of months and fully recovering versus continuing to have symptoms is a critical difference. The facts must be competent and admissible. Dr. Morley relies on statements by the employee about treatment that he had, but none of those records are in evidence, so that's not competent evidence. Opinions cannot be speculative. They are in this case during the deposition. I think Dr. Morley, starts to retreat from the explanations. He tries to stick to his guns and say, but still, somehow, I think after he has said, no, I don't think that injection in 2021 would have caused cauda equina syndrome, which was a key reason for his initial opinion in his report. And similarly, the opinion must be to a reasonable degree of medical certainty. Again, that's not here if you read this deposition with Dr. Morley. So taking all of these factors, we would submit that the impartial physician's opinions must fail as a matter of law. They cannot support the employee's claim, which even though this was a discontinuance initially, it is still his burden to show at this stage. And because
is there a, sorry to interrupt, is there a mechanism? I understand how 11A works, and here you went to the AJ and you said, look, we want to open the record and present additional, record and review evidence from other doctors. Is there a mechanism, though, by which a party can challenge the appointed impartial physician?
There may be. I'm not aware of that having been done. One thing I would also note, just with regard to the conference process and the selection of the impartial and the specialty, is that it is very clear that you can't put two. So the parties can sort of agree amongst themselves, yeah, we need a neurologist and we need an orthopedist, but you can't write, I've tried writing down two, and the judge says erase one of those.
Right, that's why it would be helpful to know what was done here.
Right.
Just
But again, I don't know that it could address the issue fully because the form and the way it's used simply doesn't permit showing everything at that stage.
I understand that. It would be strange to agree upon a physician and agree upon an area of expertise and then come back and say, well, we don't like the results. So, I mean, and I understand that that happens not uncommonly in these cases, but
Right,
that's why I was wondering if there's a mechanism.
I don't think that an orthopedic specialty is completely irrelevant. I think that both are relevant to the analysis. But in this case, the particular orthopedic surgeon didn't have experience with this sort of cancer.
Understood.
Can I ask a question? Your time is up, but I have a question still. What is the significance of the steroid injection? And specifically, if it exacerbated the symptoms and if it was needed because of the work injury, would its effects also be, work-related?
Yes, I think as a matter of law, if treatment, unless there's some sort of maybe serious malpractice issue, if treatment causes issues that was necessitated by the work accident. But as we argue, there's problems on both ends of that. One, the fact of the lifting injury even necessitating the injection to begin with. I think it was the other way around, that the symptoms were showing up most in that area at the time, so that's where they did the injection, and his symptoms continued to worsen. It wasn't cause and effect, it was kind of the other way around. But additionally, where the real problems are with Dr. Morley's opinions especially are that it simply makes no sense that an injection could cause these problems, and you can see that in the deposition. Attorney Nero starts to point out.
Okay, I think I get it. Thank you.
Yes.
We'll hear from Attorney Sullivan.
Thank you.
Morning, Your Honors. Brian Sullivan from Ketchus Law Group on behalf of the appellee. And just to answer your question earlier, inquiry about the 140 form, we did complete a Form 140. We did not agree on the name of the doctor, but we did agree on the specialty of the doctor.
What was the specialty?
It was either orthopedics or orthopedic surgeon. I don't remember exactly which one it is, Your Honor.
Okay. Thank you.
And then I believe you had a question, Your Honor, about is there a way to choose a different doctor or contest a doctor? I forget which one of the justices asked that. Not specifically, but there is a space on the form where you can write where it's almost become practice. If you don't want the assignment of a particular doctor, you can write that. Whether the judge adopts that or not is up to the judge's purview.
That's helpful. Thank you.
So I just wanted to make sure you guys didn't have any questions before I started. I didn't want to interrupt Your Honors.
Go ahead.
Okay. So, Your Honor, I think this is a very straightforward situation. My client had a back injury in 2019. Was paid workers' compensation benefits for that. Returned to work after that injury. Has a second industrial injury, almost in the exact same manner, resuscitating patients. This injury, unfortunately, is the one that ended his career with the city of Boston. He goes out of work for this injury. The city accepts the injury. They accepted liability for the injury. They began paying him benefits. So the only real issue at the time of their conference was, is the injury still work-related? And I suggest to Your Honors that it is. The administrative judge found that it was. The doctor selected by the administrative judge found that it was. And the reviewing board affirmed that decision. And I think the reason that all of that happened was he had an injury, he had an injection, and if you look at the deposition transcript of Dr. Morley, he talks about it's not just the cauda equine or the cancer. What happens is when you have an injury, there's swelling, the ligaments are pulled and strained and things like that. And when you administer an injection into that affected area, it can make things a lot worse. And that's what happened. And he thinks that's what really caused the cauda equine to really take effect and have the urinary incontinence and the fecal incontinence. And Dr. Morley, in his opinion, if you look at the last page of his report, I know there's questions about were the opinions offered to a reasonable degree of medical certainty and things like that. Right at the bottom of his report, he says, medical opinions offered to a reasonable degree of medical certainty. In his deposition testimony in the very beginning, he also gives an analysis and says this is how I come to my professional opinions. It was never an issue after that. He was never questioned about whether there were any issues with the opinions being offered to a reasonable degree of medical certainty, and that's the standard for the doctors in a workers' compensation case to give their opinions to a reasonable degree of medical certainty. And he did so, and he affirmed that in his report, and he again touched on it in his deposition testimony. So at the end of the day, I think what we have here are a lot of red herrings, Your Honor. At the end of the day, we have an impartial opinion that was adopted by the administrative judge, which is within her right to do. She also allowed the submission of medical evidence, additional medical evidence, so the parties could submit additional medical evidence, which happened in this case. That's sort of a safeguard so the judge can have all of the medical evidence that the parties want him or her to review. After Dr. Morley reviewed all that, he said the work injury is a major cause of the disability and need for medical treatment. That's not the standard. That's a heightened standard. That's when there's a prior injury that maybe is combining with the industrial injury. And he offered that opinion. Yes, to a reasonable degree of medical certainty, the work injury is a major cause of the disability, which is permanent and total, and the need for medical care. And he affirmed that again in his testimony.
What's the non-heightened standard? You said that was a heightened standard that's not applicable. What is the actual standard?
What is the actual standard, you say, Ron?
Yeah.
More probable than not? And if you look in Dr. Morley's testimony, does he go back and forth when he's questioned? Sure. But he always comes back to those same opinions. And does he say the terms may or possible? He does. But then he goes on to say probable, or I agree it's a major cause, or I agree it's causally related. Those opinions are offered in his report and throughout his deposition testimony. So in my opinion, the judge did the absolute correct thing, and she adopted the report of Dr. Morley, who's a board-certified orthopedic surgeon. And when you review his deposition testimony, which I'm sure your honors have, he did have a history with back surgeries. He had a history with oncology. He's treated cancer patients. He performed surgery at the hospital for specialty surgeries. So he does have a history with all this. He has a history with oncology. And to suggest he's not qualified to comment on cauda equina is not fair to the doctor. He gives a thorough explanation on it and a thorough explanation on why he thinks the work injury combined with anything that may have been in the past in the work injury remained a major cause of his disability and need for medical treatment. He performed a thorough analysis in his deposition transcript. So I think the judge did the absolute right thing, and the reviewing board agreed with her.
Are you arguing that that causation here is predicated on the work-related injury and the subsequent injection caused by the which was a product of the work-related injury, or either or both?
I believe it's a combination, Your Honor. Okay. And what we had is, we had an injury in 2019, very similar. Goes back and has almost the identical injury. The reason why we asked about a major cause, liability was not established for that 2019 industrial injury. So that's why we had to ask the additional question about a major cause, Your Honor, just to touch back on the question you had raised earlier.
So the cancer diagnosis obviously plays a big part in this. That's why the city came back. Does the administrative law judge discuss it at all or deal with it at all?
With the cancer, Your Honor?
Mm-hmm.
I believe I don't want to misspeak, but I believe she did touch on it in her decision. But I would suggest to you, Your Honor, even if she didn't, I don't think there would be error. People have all kinds of ailments in their life. Her job was to assess whether the person was injured in the course of their employment. Is the disability and medical treatment causally related to that injury? And she did that. And there's ample medical evidence to suggest we didn't meet our burden of proof is not true. Not only did we meet our burden of proof, we met a heightened burden of proof with the a major cause language in both the report of Dr. Morley and the deposition testimony of Dr. Morley. There's nothing more you can ask for in a workers' compensation case. And that's why we did not submit additional medical evidence, because the doctor selected by the judge said it's a major cause, and he continued that.
Well, you liked the result that you had, obviously.
I did, Your Honor. I did. I'd like it in every case. And that's the reason why we did not submit additional medical evidence, because we were satisfied with the opinions of Dr. Morley.
What about I asked Attorney Ahern this, is, what if the same injuries would have happened without the work-related injury? Because of the underlying cancer, would the city still be liable?
If he had a back injury just with cancer and no industrial accident, Your Honor?
Yeah.
I would say no.
If it was, there was this intervening accident, but if it was going to happen anyway.
I don't know if there's any way to tell that, Your Honor. And the reason I say that, Your Honor, is I think he did have some things going on in his body. And when you look at Dr. Morley's testimony, he explains why it actually progressed to the point it's in. And that's when they administered the injection into that, I guess you could call it damaged situs, where they had a lot of swelling and pulled nerves and things like that. He goes on to give a very detailed explanation on that. So would it have happened absent a work injury? I'm not sure. I don't think anyone can say, Your Honor. Nobody has any more questions? I can rest on my brief, unless Your Honors have any other questions.
Seeing none, thank you both.
Thank you, Your Honor.
You both did an excellent job for your clients, and we appreciate your arguments. Very helpful.
Thank you, Your
With that, we're gonna adjourn, I guess, for the day. Thank the court officers and the clerks and the time clerk over there, and have a good afternoon.